During a two-day national summit on justice sector reforms held in Abuja on Thursday, legal experts and key stakeholders in the justice system have called for significant changes in the appointment of judges and court administration nationwide. Lawyers have expressed concerns regarding the dual role of the Chief Justice of Nigeria, Olukayode Ariwoola, who serves as both the chairman of the National Judicial Commission, NJC, and the Federal Judicial Service Commission. Critics condemn the extensive powers wielded by the CJN, particularly as the NJC is automatically chaired by the CJN. Proposed reforms aim to curtail the vast authority of the CJN's office and mitigate the undue influence of the CJN and other court heads in judicial institution administration. We're joined this morning by Sam Kargbo, who is a senior advocate of Nigeria. Good morning and thanks for joining us.
Good morning and thank you for having me.
Good to have you. Do you agree with these reforms that have been proposed? Do you also see the challenge that has been pointed out here?
Okay, let me look at it this way, because if I say yes or no, it may not amount to anything. You know, the Chief Justice of Nigeria is both a serving justice of the Court of Appeal and the administrative head of the entire judiciary. That in itself is a very powerful, important, and engaging position. In addition to that, he is also, like you rightly pointed out, the chairman of the Federal Judicial Service Commission. This is the commission that audits, I wouldn't say selects, but audits those that are considered to be qualified for appointment into the high courts, the Court of Appeal, and the Supreme Court. It's a very serious position. And beyond that, he is also the chairman of the National Judicial Council, which in itself is also the recommender of those to be appointed as judges, justices of the Court of Appeal and the Supreme Court. This is also chaired by the Chief Justice of Nigeria. This and the Chief Justice, because of his office and because of the functions of the National Judicial Council, is also the administrator of the funds of the judiciary. Important office, important position. And what has been happening over the years, if you see, let's take those three items that I've discussed about: the appointment, the administration, and the control of the finance of the judiciary. Let's start with the appointments. From the books, if you look at the books, if the process were to be handled and managed by an AI, we would have had what? One of the most fantastic judicial officers in the world, because the books are very clear. Before you are appointed as a judge or as a justice of the judge of the High Court, a justice of the Court of Appeal, a justice of the Supreme Court, you must be first and foremost a lawyer. And the number of years post-call you ought to have had ranges between 10 and 15. That by itself would have exposed you to some grinding within the rules of the legal profession. The rules of the legal profession call for higher standard. I've also had to say this over and over, and I'm saying so, than that which you require from what? An imam or a bishop. If you take a look at the rules for you to be a lawyer and remain as a lawyer, if those rules are actually implemented, you will be much more forthright, and you will be of a better integrity and personality than an imam or a pastor or a bishop, in fact. So it is from among the lawyers, elite class, whose standards should be over and above the average, that what lawyers or judges and justices are to be appointed. The rule does not say that a justice of the Court of Appeals should come from what, or should be promoted from the High Court. And the Constitution does not say a justice of the Supreme Court should be promoted from the Court of Appeal to the Supreme Court. Say no. If you are a lawyer of 15 years standing, you are qualified to be a justice of the Supreme Court. But what has happened over the years? The judiciary has hijacked that. They've appropriated that process and ensured that no outsider comes in. In the 60s, we had the cases of Elias and a few number of gentlemen who were appointed from public, private practice or the universities into the Supreme Court, and they did fantastically well, if that English is correct. But over the years, no. They've appropriated it, excluded lawyers, practicing lawyers. If you are not a judge, you cannot get into any of those three tiers. And that has been the problem, because here it is. There are sectors and areas of the law that require some form of expertise, just like they are doing for the Sharia. They leave a quota for Sharia, that you must have a background in Sharia before you could what? Come in as the Justice of the Court of Appeal or Supreme Court. But all other areas, take a look at emerging areas like AI, intellectual property. These are very, very technical areas that you would have needed people either from the academia or people of established expertise from the private practice. But oh no, those people are shut out. Because what? The judiciary has appropriated the process, and they will tell you over the dead body, you wouldn't come from without. So that in itself is a problem. And who is at top of it? The CJ.
And who can correct this, if I may ask? Now that you've highlighted these challenges, and if the CJN is at the top of it, who can make this correction?
That's what I'm saying. And that is why the stakeholders are reacting the way they are reacting. Because what? It's more or less a vote of no confidence on the system, and perhaps what? The performance of the office of the Chief Justice of Nigeria over the years. Because if indeed, like I have said, the system was allowed to function the way it is in the books, we wouldn't be having this. But take a look at those who are being appointed as judges of the Courts of Records. Take a look at their background. Almost all of them are coming from either relationships they have with existing judges or politicians who would say, okay, like in my state, if the NJC say, okay, we want you to have 7 judges to add to your own bench, the governor would say, okay, I will take 5. CJ takes 2. And that's the way it is. Once that list comes from the governor and what do you call it, piloted by the CJ, that is the way it's going to be.
So is it maybe time to revisit the rules for, appointing these judges and the role that the executive has to play? Some have argued that the executive should be totally removed from issues concerning the appointment of the judiciary.
They shouldn't have any business with it.
Okay.
But in the books, theirs is for what? Confirmation. But in actual fact, they are the pilots of the process. You cannot be a judge of a state without what? The signature of the or the authorization of the governor. And you ask the question, what is the function of the state judicial commissions or the Federal Judicial Commission? When you look at the composition of that body, you'll be amazed, because what? It comprised people of a sterling standing in the profession and in the judiciary. And yet these people are bypassed, and the entire process is piloted most time in the state. The three people that handle the process, I am saying so, quote me, the CJ, he's, what do you call it, he's chief registrar, and the governor's office. That's what you have. But meanwhile, the system in the books is layered to ensure that, yes, you have the judicial commissions, then you have the NJC, which is also what? Constituted by every rank and file. The CJ, the president of the Court of Appeal, chief judges, lawyers, and even people from the private sector who have what? A standing character. And yet, these people are bypassed because of what? The commanding nature of the office of the CJ. And whatever he says, hey, that's what matters. And one would ask, what else would you want the books to do? Because at the end of the day, no matter how fine your letters are, the human angle would subvert that. That is the problem here.
All right.
And now you come to the other aspect of it. Management, control, and disbursement of the funds meant for the judiciary.
Yeah.
We were scandalized to a point where most of us said, oh no, this shouldn't have happened. Whereby you see the justices of the Supreme Court more or less rebelling to say, oh no, we've had enough. Gentlemen, you are misusing our funds and we are starving, to the point that they forced a CJN to resign. Where on earth would you have what? Imagine that would happen.
Yeah.
Only here. And what am I talking about? The human angle.
All right. Before we go,
how do we humanize ourselves to the point that what? The fine books would be translated in fine practice. The fine law would what? Be translated and express what? In fine habits.
Leonard SAN, you've highlighted these key problems, and thank you very much for sharing your standpoint. We hope that the judiciary can look within and that they can start to see these issues and look for the way out to resolve this. Thank you so much for your time with us this morning.
Thank you very much.
All right.